Hey, friends. Welcome to my Facebook and my YouTube channel, Attorney E Immigration Lawyer. It's been a long time. I was on the road. There's so many things that happened. I was in the Philippines. I attended so many things. I had an exhibit in San Francisco, and I was not able to record anything about immigration law. So, pasensya na po kayo. But today, I promise that I'm going to talk about yung June 18 executive order or executive action ng Biden-Harris administration. This is to promote the unity and stability of families. Now, I want to just want to make sure that we're live on YouTube and Facebook, okay? Ayan. So, okay, so before I start, I want to introduce myself. My name is Attorney Elaine Antonio Bordeaux. I've been practicing U.S. immigration law since 2008. So I've been practicing U.S. immigration law for more than a decade. And today I want to talk about tonight. We're actually what time now? 8:17 in Colorado. So I want to talk about this executive action. This is very important. So this executive action or announcement by the White House on June 18. So sabi nila the purpose is to promote family unity and stability. So this will benefit your spouses of US citizens, children or stepchildren of US citizens, and there's a part for the dreamers here or yung mga DACA visa holders, remember? So this executive action is actually divided into three parts. And, the first part is about the spouses of US citizens, yung mga undocumented spouses of US citizens who were not admitted or paroled. So not everybody will qualify. So I'm going to talk about the eligibility requirements. Kailan ba yung application ito? According to USCIS, application will begin on August 19. So ayan, malapit na ha. So you have to make sure that you have the evidence that you need. So August 19, USCIS will begin accepting applications. And I'm going to talk about the evidence that you can present. Okay. So there are three parts to this. The first part for spouses, the second part for stepchildren of US citizens, and the third part are for the dreamers or DACA visa holders or DACA holders. Okay? All right. So yung mga DACA holders, we call them the dreamers. They were children brought to the United States when they were young, and then eventually DACA was put in place, and they were able to go to school. They were able to attend high school and college, and now most of them have completed college and have been gainfully employed, contributing to society, and so this executive action will benefit them as well. So I'm going to share with you my screen, and pardon my voice because I've been talking so much and I've been drinking too much cold, so my voice is not cooperating. You can find this post on USCIS, reminders on the process to promote unity and stability of families. Okay. All right. So this presentation I'm going to share with you my screen. All right. Okay, there you go. So first and foremost, I want to remind everybody that there's no attorney-client relationship established by just watching or listening um, in this presentation. Of course, if you want to schedule a consultation with me, you can do so. Text 713-315. Okay, I do have a banner for that. I know somewhere here. Okay. For consultation, please email eboardlaw@gmail.com or okay, eb@eboardlaw.com. You can do that. All right. So I want to talk about this post by USCIS. Okay. So on June 18, President Biden announced new actions to keep family together. So we're talking about spouses of US citizens who could not simply adjust status. Okay, so what are the eligibility requirements? Because not everybody can benefit from this. Okay, and in this post by USCIS, it is stated here very clearly that this is a case by case basis. This is going to be a request for parole in place, and this is going to be discretionary. Okay, so what are the eligibility requirements? Ano ba yung mga kailangan? What do you need to show to benefit from this? Okay, number one, to be considered for a discretionary grant of parole on a case by case basis, you must be present in the US without admission or parole. So, presence in the United States without admission or parole. So, if you have been admitted or paroled, you cannot apply um, of under this executive action. So that's clear. You have been continuously present in the US for at least 10 years as of June 17, 2024. So go back 10 years. You must have been continuously present in the US for at least 10 years. As of June 17, 2024, you have and you have to be legally married to a US citizen as of June 17, 2024. So if you're married after June 17, 2024, then you may not apply under this executive action. And you do not have any disqualifying criminal history. You're not a threat to national security or public safety. And you merit a favorable exercise of discretion, meaning this is a discretionary relief. Okay, this is a case by case. It's going to be decided on a case by case basis. All right, so okay, so those are the eligibility requirements. Now, hindi lahat will qualify. As I said, June 17, 2024 is the cutoff date, and you must have been here for 10 years na. And you must be married to a US citizen as of June 17, 2024. Okay, so kung because of this, nagpakasal ka, after June 17, you're not qualified. And here's the thing here. You must have been present in the US without admission or parole. So if you have been lawfully admitted and then na-expire status mo, you will not apply under this executive, you may not qualify under this executive action because there are other benefits or relief that you can apply for. Okay? All right. So paano naman yung mga anak? So that's the first part. So that's the spouses of US citizens. Now, according to the fact sheet issued by the White House, this will benefit around 500,000 spouses of US citizens, ano? And okay, no, 500,000 spouses of US citizens and approximately 50,000 non-citizen children under the age of 21 whose parent is married to a US citizen. So we're going to talk about part 2. Ito yung part 2. Okay. So under the part 2, USCIS may also consider certain non-citizen children of requestor. So requestor yun yung parent na spouse of US citizen. As of June 17, 2024, if they were physically present in the US without admission or parole and have a qualifying stepchild relationship to a US citizen. Now, the stepchild relationship to a US citizen, merong technical meaning sa immigration. Dapat married before the child is 18 years old and the child is below 21 years old at the time of this application. Okay? So, dapat kinasal sa magulang na ang bata ay below 18 and then at the time of the application, dapat below 21 years old. So, that's the definition of a child. And that's the definition ng stepchild relationship to a US citizen. Okay? All right. So, sabi dito timeline, you cannot apply for this process yet. So this is not yet open for application. If you apply, USCIS will reject your application. Okay, so it also stated here that USCIS is not currently accepting application, but they will begin accepting application on August 19. Ayan, so malapit na August 19. So how many days na lang from now, 'di ba? So July 30 now, 31, and then August 1, and then August 19. So you can start applying. Okay, but right now they're still working on their process, and then they will make the announcement when it's ready for application. Okay. All right, so that's the second part. So the first part is for the spouses of US citizens, and then the second part for children or stepchildren of US citizens. Okay, and so, but and the third part, okay, so the third part is not on this post, but it was on the fact sheet issued by the White House. Ang sabi dun sa third part, and I'm just gonna read this, okay? Sabi, today's announcement, or June, it was announced on June 18, it will allow individuals, including DACA recipients and other dreamers, who have earned a degree at an accredited U.S. institution of higher education in the U.S. and who have received an offer of employment from a U.S. employer in a field related to their degree to more quickly receive work visas. Okay? So, sabi dito, DACA recipients, dreamers who have earned a degree. So there must be a degree earned at an accredited U.S. institution of higher education in the U.S. and must have received an offer of employment. So there's going to be a process for a quick work visa process. Okay, recognizing that it is in the national interest of the United States to ensure that the individuals who are educated in the US are able to use their skills and education to benefit the United States. The administration is taking action to facilitate the employment visa process. So there's going to be an employment visa process for those who have graduated from college and have a high skilled job offer, including DACA recipients and other dreamers. So, graduation from a US accredited institution of higher education and a high skilled job offer, okay, including DACA recipients and dreamers. So, that's the third part. Okay, so first part, spouses, second part, stepchildren, and then third part naman ay dreamers, DACA recipients, and those graduates of accredited U.S. institutions of higher education. Okay, ayan. So those are the requirements. So what can you do in the meantime? In the meantime that we're waiting, for now, USCIS is not ready to accept your application. If you submit an application, get it is going to get, how do you call this, rejected. Okay, so you know what, this is supposed to be, let me just give you our new email address. It is eb@eboardlaw.com. If you want to schedule an appointment, yeah. Okay, hold on just 1 second. Okay, so that's the right email address, eb@eboardlaw.com. Okay, so what can you do in the meantime? Because USCIS is not yet accepting applications, you can start gathering information. So, according to this post, although USCIS is not currently accepting applications, you can begin to prepare a parole application by gathering evidence of your eligibility, such as, of course, evidence of legally valid marriage as of June 17, 2024, marriage certificate, documentation of proof of identity, including expired documents, may include valid state driver's license, So, proof of identity, even valid driver's license, and it's stated there, even expired documents may be submitted. Birth certificate with photo identification, valid passport, or any government issued document bearing the requestor's name, date of birth, and photo. So may mga nagtatanong, if you're out of status, can you still get a passport? Yes, you can. Okay, so that has nothing to do with US immigration. You have to deal with your embassy, you have to deal with your consulate. So if you're from Mexico, then you have to contact the embassy of Mexico or the consulate of Mexico. If you're from the Philippines, then you have to contact the consulates of the Philippines or the embassy of the Philippines in order to get a passport. Your immigration status in the United States is not relevant because your passport will be issued by your country of origin. Okay? Ayan. Klaro yun, ha? Ito, ano naman yung mga evidence that you have been continuously present in the US for at least 10 years as of June 17, 2024. So, you have to show 10 years of physical presence in the US. So June 17, 2024, go back 10 years. Rent receipts, it's actually stated here, school records, hospitals or medical records, attestation to your residence by religious entities, unions, or other organizations. So you can get your church to attest that you have been coming to the church since what year, that you have been present in the United States for 10 years. Official records from religious entity confirming participation in a religious ceremony, money order receipts. If you have been sending remittances to your country, then you can present receipts, money order receipts or remittances. Birth certificates of children born in the United States. So marami nagkaroon na ng anak in the US, then you can show that. Bank transactions, you can get bank statements, automobile license receipts, title or registration, deeds, insurance policies, tax returns, or tax receipts. Okay, so many, even those who do not have employment authorization, actually, many people are filing their tax returns every year. Okay, for non citizens, naman, you can show evidence of child's relationship to the parents, such as birth certificate or adoption decree, evidence of parents' legally valid marriage to a US citizen, of course, marriage certificate, and then evidence of child's presence in the US as of June 17, 2024. This includes, uh, vaccination records or health records, medical records, school records. There's so many evidence that you can get for a child to prove physical presence in the United States. So you can go to the hospital, you can go to the health centers, you can find the records, you can request for medical records, you can go to the school and ask for the school records of the child, and you can show that the child has been in the United States as of June 17, 2024. Okay? All right. Now, there's a warning here. Mag-ingat sa mga scammers kasi marami pong mga scammers. As you can see. Okay. Ayan. So right now, they're not yet accepting. It will be August 19 and they will make an announcement. So abangan po ninyo for new announcements. Make sure that you subscribe and then follow me ang aking Facebook page and ang aking YouTube channel, Attorney E, Immigration Lawyer. Medyo pagod na ako. It's been a long day and I just really want to do this because many people are waiting on this. So I hope I was able to share with you what you need to actually prepare the documents that you need to submit when USCIS is ready to accept your applications. Okay? So, ayan po. Until next time, Attorney E, if you want to schedule a consultation with me, email eb@eboardlaw.com or mag-text 713-315-7793. Thank you. Bye.